Hey, you shake your head. Did you or did you not plead guilty under oath?
Yes, sir.
Go ahead, lie to me. I mean, we got the record. That's why, and I would have had to say, there is enough evidence here to find you guilty, but I'm going to defer any finding.
Yes, sir.
So I made a finding, and I'm sorry, you pleaded guilty under oath.
Yes, sir.
And here you are. Hold it down. Thank you.
Okay.
Pleaded true in April on 2 allegations, and then the MTRP was dismissed in June. Is that right?
I don't know if that's correct.
That's what it says.
We did a new administrative hearing and a new motion to revoke.
Oh, so that's correct.
It's just five.
Judge, there was a prior MTRP dismissed. I cannot,
Okay, I'll
I
get
don't remember a
that.
plea of true to, don't remember what the pleas of true may have been to.
I've got them on there. There were 2 administrative things.
They were maybe administrative that.
Okay, so there was another motion to revoke probation in this case filed August 17th.
That's the one I'm looking at. Yes, sir.
Just filed. Something was word for word from the earlier motion, some are new. And it's got 7 alleged violations, illegal possession of marijuana, failed to avoid persons in place of the character, failed to provide information upon the community service. We lost drugs, marijuana, failed to take for distance fees, failed to provide verification of completing moral reclamation therapy, failed to meet the requirements of zero tolerance.
Stored is today.
No, that's okay. So you've got a new set of another motion just filed a few days ago that I had signed off on August 6th. That is, what do we have?
Judge, I filed a request for bond. He's on deferred probation.
What's his bond now?
There's no bond. It's probation, so it hasn't been set in. Now, I would like to point out a few things, though, Judge. It's definitely weighing in his favor. When he was arrested for the new offense, which is the main reason for the MTRP, he immediately contacted me because it was apparent that somebody else was responsible for the new offense. I had an investigator do some investigating. He did locate a person who claims to be the responsible party for the new offense. I provided
What's the new offense?
possession of marijuana. I provided that information. I don't think we're at a point where that can be looked into or vetted, but it is part of the situation. And I just wanted to bring that to the court's attention.
John, I would like to point out that
I'm a little fuzzy. Okay. Violation of condition 10 here on this administrative hearing. Illegally possessed drugs, namely tetrahydrocannabinol. Comments. Offense material states the defendant had the illegal substances on his person as
That's right.
well as in his vehicle at
That's
the
right.
time of the offense.
there was marijuana found in the
So how's
trunk
it-
and marijuana found in the defendant's pocket as well.
Well, there are 2 different substances. One was a large amount in a backpack, which was really the reason for the arrest. Well, no, hold on. The amount in the pocket would be a misdemeanor. He was arrested for a felony. So he was arrested for the large amount in the bag. A separate amount was found on his person. I would imagine that's being tested separately. At this point, we're not saying that somebody else is responsible for something that they found in his pocket, but his arrest was for a felony amount of marijuana. It was an amount of marijuana found in a backpack. And that is apparently someone else is claiming that is theirs.
Unsubstantiated, unverified. Yeah.
I've given that to them. That's their job to verify and substantiate it. I've turned it over to them. My investigator is a former Harris County Sheriff's deputy who investigated the homicide division. I trust his recordings and his contact, but I just give that to the state.
He wasn't on the scene and he didn't fill out the statement, the purported statement claiming responsibility.
Okay, it's the however portion. It should be noted that the defendant was found to have marijuana on his person during the traffic stop as well. He is aware he is not permitted to possess any illegal substances in any capacity. He was granted an additional chance at being successful on probation by this court by being placed on zero tolerance supervision and having his MTRP dismissed, but has continued his criminal behavior. This officer believes the defendant lacks the desire or ability to be successful on supervision.
Ms. Lopez.
What is it about thou shalt not commit a crime, which you're in possession of marijuana? Isn't that a crime? And you can't say it's just a little bit. That's like saying I'm just a little pregnant. You're either committing the crime or not. That's the rules that we have to follow. Do not commit a crime. Number one. Here we are. How many times do we do this? But you can't say, well, it was just a little bit. It's wrong. How do you explain it? I don't care, but if it's not on your possession, if you want to say it's somebody else's, it's up to the state to prove that. But it's on you, in your possession. Shame on you. Well, we've done this before. Here we are again. Open the door for one, open the door for everything. Don't commit a crime. Don't possess any drugs. You're still doing it. Do you understand?
Yes, sir.
Why? I mean, everybody's disappointed. You know better. You made a big deal about this purchase. What are you asking?
Judge, we're asking for a bond of 7,500. I think considering the circumstances, I would want to point out one thing. As soon as he was arrested, he contacted me because of that issue. You need to put that in the issue of somebody else being responsible.
I'm talking about what's in his pocket.
I understand. We don't have offense materials, Judge. I don't. We've not seen any police reports. But the other thing I want to point out, which I think is very important, as soon as this court issued the MTRP and a warrant went out, he went and drove and turned himself into the sheriff's department that day.
Okay, he was supposed to.
I understand. I point that out because he wants to take care of responsibility. He was not running or hiding from this in any way. He was trying to do what he could to get ahead of it as much as possible, which is not what everyone does. So I just wanted to point that out to be considered by them.
You don't need to struggle and try to stay ahead of everybody if you don't have it in your pocket. Gosh darn. Made a big deal about it. That's a crime. Where are we on that?
My record respected, it has not been referred to our office yet.
I imagine it would take another 2 months probably.
What are you asking?
We certainly defer to the court. We just simply ask the court set a bond that's consistent with the noncompliance of the defendant, or at least the alleged noncompliance, and that's sufficient to secure his appearance at any future court appearances.
What do you think is fair?
Judge, given the fact, and I'll concede, it is a non-violent offense, albeit an offense. We've seen worse violations. Taking that into consideration, Judge, I would say a bond on the low end. I don't think that a bond in the area or in the vicinity of what Mr. Gallimore is asking for is unreasonable. Maybe something between $7,500 that he's asking for and $10,000, Judge.
What's the charge here? You pleaded guilty to this, and we placed you on probation. But what is it? You intentionally knowingly entered a home without the consent of the owner with intent to commit assault? Hey, you shake your head. Did you or did you not plead guilty under oath?
Yes, sir.
Go ahead, lie to me. I mean, we've got the record. That's why, and I would have had to say, there is enough evidence here to find you guilty, but I'm going to defer any finding.
Yes, sir.
So I made a finding, and I'm sorry, you pleaded guilty under oath.
Yes, sir.
And here you are. Again. Violent crime, now we're in drugs. He's asking for 75. You don't have you think that's okay?
I could see how the court would grant that, Judge. I think if pressed,
You don't have an objection to that.
I don't have an objection to
All right,
that.
that's what it's going to be. But you're going to have some kind of a drug patch
Yes, sir.
at all times. But this thing marijuana comes back, we're going to have a hearing on the motion to revoke probation.
Yes, sir.
Good luck.
Yes, sir.
Thanks, Judge.
7,500 and start.
We gotta get it.
Moment we get the drug tested and confirmed, we're gonna have a hearing as fast as we can.
Yes, sir.